Good afternoon. While I was sitting in court today, waiting on my case to get called, I was reading comments, and there was actually a pretty good comment by, surprisingly enough, not a sovereign citizen. So that's great, right? His argument is that in order for photography to be protected, you have to affirmatively show two things. Number one, you have to show that there is communicative intent behind taking the photograph, and number two, you have to show that there is a target audience. Now, his support is somewhat weak for this proposition, but we're going to go through and we're going to figure out exactly why. He cites the first case he cites the case he cites to support it, that is the best direct support, is Schloss v. Lewis. Now, Schloss v. Lewis, a guy was walking around a fairgrounds of some sort, and he was taking pictures of little girls. And people didn't like that. They called the police. The police came. He started deleting photos off his phone. The police seized the phone. They find kitty porn on it. Woo! Another porn case. Gotta love those porn cases. This is a kitty porn case, and as we know from First Amendment jurisprudence, child pornography is not protected by the First Amendment. The United States of America as a whole despises child pornography and child molesters. Hence, a lot of the people in this particular community aren't well beloved by the public. You know who you are. So, for whatever reason, I'm not entirely sure, the state brings several charges. They bring him up on charges twice, I believe. Both times it gets dismissed. And so then after all this dismissal, he goes ahead and he files a lawsuit for deprivation of rights under the First Amendment. The government violated his right to take pictures at the fair. Sounds cut and dry, right? Well, sorta is and sorta isn't. First of all, this is a district court decision from the Second Circuit. And district court decisions, as we have already determined, are at best persuasive. They are not precedent. A court is not bound to follow a district court decision. They can cite it as support, but it is not precedent. So that's issue number one. Issue number two is, what are they talking about? They're talking about child porn. They're talking about a guy taking pictures, presumably of young ladies, like upskirt or down blouse or compromising positions, things that might appeal to prurient interests. It might be, loosely speaking, child pornography. And so in order to have a protection under the First Amendment, in order to have a protected right under the First Amendment, he would have to prove that, number one, he has something to communicate. And number two, he has a target audience to communicate it to. Now, if it is in fact child pornography, well, guess what, kids? He would have to basically admit to making and distributing child porn. And then he still wouldn't get the First Amendment protection because, as we all understand, child porn is not protected by the First Amendment. In the alternative, he can keep mum on the issue, in which case the court doesn't want to reward a pedophile. I mean, the guy, it was right for the cop to get there. There was child porn on the phone. The court does not want to protect this guy. The court is going to find a way to deal with it. And the court found a way to deal with it. They cited Porat versus Lincoln Towers for the proposition that in order for photography to be protected under the First Amendment, you have to prove, number one, that you're communicating an idea, and number two, that you have a target audience. Because basically he was constrained from doing that, well, sorry, son, you lose. So now you're going to say, well, obviously Porat versus Lincoln Towers, that is going to be the smoking gun to prove that you have to have an intent to distribute the photography, and you have to have an audience to distribute it to. You have to have a communicative idea and an audience to distribute it to. Well, so Porat isn't really deciding that issue. Porat is an appeal off of a motion to dismiss that was granted. In Porat versus Lincoln Towers, Porat was videotaping or filming something. He was molested, accosted, whatever. He filed a lawsuit. And in his lawsuit, he alleged that his First Amendment right was violated because his free speech was chilled. He wasn't able to freely speak anymore from threat of government intervention. I haven't read the underlying case in a long time, so I'm not giving you very specific facts, but they're not really relevant to this particular analysis. He filed his complaint, and then he filed a First Amendment complaint as a matter of right before the defense filed an opposition, or a response, I should say. The defense chose to file a 12b6 motion to dismiss rather than a response, and he lost on that motion to dismiss. In his opposition to the motion to dismiss, he asked for the opportunity to amend his First Amendment amended complaint. Now, generally speaking, the court is to liberally grant leave to amend a complaint. He didn't have it as a matter of right anymore because you only get that once, and you only get it before a response has been filed. At the point where the motion to dismiss was granted, a response had been filed, and he had already amended his complaint once, so he's 0 for 2. Well, in his opposition, he requested the court grant him leave to amend, and the court didn't address that in granting the motion to dismiss. So rather than asking for leave of the court to specifically address whether or not he could file an amended complaint, he instead filed an appeal. And the reason why his complaint was dismissed, why the motion to dismiss was granted, was because you have to specifically allege facts. You have to allege facts that support your claims. You can't just say, my right to the First Amendment freedom of speech was chilled. You have to say how it was chilled. You have to allege the facts that you were trying to engage in free speech. You have to allege that. You have to say, I'm trying to communicate an idea, and as a result of the government's activities, my ability to communicate that idea has been chilled. It's a fact you have to allege. If you don't allege that fact, you can't proceed. Now, it's a very easy thing to do, to allege a fact. You could just say the things, the government interfered. I'm afraid now to do X, Y, and Z, and that fear is a direct result of the government's intervention. It's easy to do. Why he didn't do it, I don't know. But bad pleading causes problems. So that's what attorneys are for, and that's why some attorneys are better than others, because of the pleadings. So the court granted, or the circuit court affirmed the motion to dismiss. He didn't follow procedure, and he did not allege the things that he needed to allege. There's no abuse of discretion. So the third case that was cited was Texas v. Johnson. Now, Texas v. Johnson is a conduct-based restriction. Johnson burned a flag. He's in violation of the Texas statute about flag burning. You can't burn flags. But he says, but I was doing it as speech. It was symbolic. And so the court, in order to determine whether or not conduct is speech, they have to determine, number one, if there is some sort of a communicative intent. Are you trying to communicate an idea? And number two, if there's an audience for that, and if the audience can understand what you're trying to communicate. If somebody burns a flag, it doesn't necessarily mean they're trying to speak. They might just be burning a flag. I mean, that's how you retire a flag. You burn it, right? So when conduct may or may not be expressive, it may or may not qualify for First Amendment protection. In order to get First Amendment protection, you have to allege and to survive motion to dismiss, you have to allege, and in order to win, you have to prove that you were actually intending to communicate an idea to an audience who could understand that idea, which is different than photography. Photography is not conduct. Photography is like putting your pen to paper. Oh, that's conduct, right? Writing is putting your pen to paper. That's conduct. No, it's part of writing and publishing, disseminating written literature. And that's what Turner v. Driver was talking about. Now, the fourth case that this person brings up was Hurley v. the Irish American Glib Club of Boston. Gay, lesbian, intersex, and bisexual or something. I don't know all that it stands for. I know gay, lesbian, and then other things. Bisexual, I don't know what the I stands for. And I'm a Californian. What are you going to do? There's too many letters nowadays for me to remember. So in that case, he says that case also stands for the proposition, and he actually puts in quotes a quotation that is supposed to be from that case, saying that there has to be a message to communicate and an audience to receive it. That language does not appear in Hurley. It just doesn't appear in there. So he is misquoting. The quote is from something else entirely, don't know what it's from, but Hurley stands for the proposition that the organizers of a parade can use their First Amendment right to exclude messages that they don't agree with, because a parade is communicating ideas. And they don't have to communicate your idea. They can communicate the ideas they want to communicate. That's what Hurley stands for. It has nothing to do at all with having an audience or intending to communicate. Taking a picture is intending to communicate. You're taking the picture for the purpose of getting a photograph at the end of it. And the photograph is to be viewed. It is for people to observe. Just like the pornography, it is for people to observe. And people have the right to observe that photograph. So anyway, I hope that explains things. It was an otherwise good comment, except for the misattributing of a quote to Hurley v. the Irish American Glib Group of Boston. So if you fix that and maybe find a better quote to land on, that would help you. But I hope I showed that your case isn't as strong as you want to make it sound. Thank you very much for watching. I hope you learned something, and have a great morning.